All right, thank you everyone for coming and spending your evening with us to talk about adjudication in the Nooksack Basin. My name, as Barbara mentioned, is Mary Berner. I lead the Water Resources Program for the Washington State Department of Ecology. And I really appreciate how many of you have taken the time to join us this evening for this important topic. Give me just a second. I'm having some technical difficulties on my end, and it looks like, Barbara, we have some more people coming in. So let me resolve my technical issue and let's admit a few more people, please.
Thank you, will do.
Thanks, Barbara. So the Department of Ecology has been working for many years in the Whatcom County community on difficult water use issues. In fact, like Robin, I recognize many of the names here this evening as folks who worked in partnership with us on water use and stream protection in the area. For the past 2 years, we have been meeting with leaders and community members about tonight's topic. So some of you certainly have seen me before, or Robin, and most of you have seen Casey Cycler, who has represented ecology for many years in the Whatcom County community. Others of you may be hearing this for the first time. So we welcome you and we look forward to hearing your questions, not only tonight, but throughout the upcoming year. So Department of Ecology's role is we are the state agency that manages all of our water resources, which includes the water of the Nooksack River system and the adjacent subbasins in Whatcom County, which we refer to as Water Resources Inventory Area 1. You're the number one, WIRA number 1 in the state. We follow the laws that tell us who can legally use water and how much water needs to remain in the streams. Ecology works in your area to ensure that water use is fair and legal. You may have applied for a water permit, or you may have participated in some of our rulemaking hearings. Adjudication, which is what we'll be talking about this evening, is another tool, like a water permit or a rulemaking, that provides us an important step in the process toward long-term solutions to meet many needs for water resources in the face of a scarce supply. We've been involved locally, as I mentioned, for many years now, and we appreciate the concerns that we've heard. Farmers who've invested in their crops, workers who want to know about the irrigation water, homeowners on private wells, builders who need to understand whether they can get a building permit with the water right, tribes and commercial fishers worried about fish, and community members asking for a healthy environment and a vibrant economy, and wondering about a lot of things, about our orca population. Adjudication is a process that will help bring certainty around the water aspects of those issues. So Whatcom County and other local governments also have important roles in adjudication and in water management. Whatcom County is responsible for growth management planning and building permits. And the cities like Bellingham and Linden and Blaine supply water directly to their customers within their service areas. Ecology is committing to working with these local governments and other local partners on water solutions. We've been here for years doing this, and we'll be here for years to come, working with you on solutions. The adjudication is a process that quantifies legal water rights in an area. You're going to hear us explain that in greater depth. It is a process that requires preparation, and we are preparing to initiate an adjudication sometime after June of 2023, but we want to let you know what we're doing in this preparation phase. We will explain what an adjudication is, why ecology is taking it on in this area, and what it means for you. As Jimmy mentioned, this will be the first of a series of meetings throughout this year. And without further ado, team, I think we can just go ahead and jump in and start describing what adjudication is all about.
Thank you, Mary. Barbara, could you let me know if my sound is working?
Sounds great.
Excellent, thanks. Welcome, everybody. My name is Robin McPherson. I'm the adjudication manager for the Department of Ecology. I have worked on water issues in the Nooksack watershed for many years, previously as an assistant attorney general representing the Department of Ecology, and now at the Department of Ecology, looking at how adjudication could be the right fit for moving into the future and solving problems that have to do with water in this area. So I know there's a lot of questions about this, and I really appreciate people that took the time to send questions beforehand. One of the questions was, how can you explain adjudication as simply as possible? And I don't know if that's someone who's seen one of these presentations before and who's giving us feedback that it's usually not simple enough. And so I'm really going to try today to start with the question of what is it? And if there's other questions, where is it, why, and how, we'll be getting to those in our future slides. But just to start with, what is this that we are talking about? Adjudication is a kind of process. We are the state government. We do different kinds of regulatory processes. Mary talked about permits. And rulemaking are things we do in water law. Adjudication is a different way of approaching water regulation that we have in our law that applies the law to existing water rights in an area. Adjudication isn't our goal in itself. Adjudication is our pathway. And we'll be talking about it as a pathway today, or the road that we are taking. We are starting to get on the road this year. And we'll talk to you about where the road is going and what the journey will be like. In an adjudication, it happens in the Superior Court of your county, Whatcom County. The Superior Court in an adjudication is the reviewing body that looks at all water rights on a water source in an area. And in doing that, the Superior Court's goal, literally the judge's goal, is to prioritize the legal rights in an area from oldest to newest. And the reason for that is that in the state of Washington, the law of water rights and the answer to fairness question on water rights is that first in time is first in right. And we know that there's competition for water rights. We know that there's water under pressure, depending on which river, stream, or tributary or aquifer you're looking at. The answer to the question of what is fair, there's different ways different states do this. And in Washington state, we look at prior appropriation. And so it's really important for us to identify legally who is the oldest user on a water source and who are the newer users on a water source. And so an adjudication is asking everybody in an area to tell us, and for us to tell the court, how much water that they have used and when they started using it. This process is really the only way to identify all legal water users on a source. Now, we have a lot of records at Ecology. If you have a permit or a certificate or a claim of water, that's good documentation of a water right. But it's not everything we need to know, and it's not all the information about what is going on the water source that is adequate to really identify all legal water users relative to each other. Adjudication is a single process that looks at all water use history and law on a water source. And the result of an adjudication is a final court decree, and the court decree has what they call a schedule or an inventory. And the inventory has water users in order, starting with the earliest recognized water rights from oldest to newest. And for each water right, it will list the party, the quantity, the purpose, and the place of that legal water use within the area. Next slide, please, Chris. So in 2019, the legislature asked the Department of Ecology to conduct an assessment. And they said adjudication looks like a really valuable, powerful tool for us to figure out where legal water use is. In fact, a lot of people in the legislature and a lot of people in the public might assume that we have already done this. A lot of people who are new to water might think, obviously, we already know exactly who is using water where and whether it's legal. But the reality is that we don't have that information, and that it's the court's job under the law to come up with that comprehensive inventory. So in 2019, which I'll joke now is a lifetime ago, a long time ago now, in terms of our current reality and the way time passes now, the legislature asked the Department of Ecology to conduct an assessment and look all around the state to see where water faces the most uncertainty, conflict, and risk. We have 62 what we call WIRAs, water resource inventory areas around the state. We have many dozens little adjudications that have been done over the years, but we really only have one large adjudication that has been done completely, and that's in the Yakima Basin, our Aquavella adjudication. And so the legislature asked us to look statewide at where future adjudications might happen. They said, where are the current tools of managing water insufficient? Where will adjudication help? And the idea was to follow the success of Aquavella, which is the name of the adjudication in the Yakima Basin, which concluded around 2019 and just had some appeals, but is wrapping up in the Yakima Superior Court right now, looking at where should be the next adjudication or adjudications and where they should go. And so we conducted this adjudication starting in 2019. We looked all around the state at different water situations, water areas. Some areas have rules, some areas have different kinds of planning. Some areas are mostly cities, some areas are mostly farms or otherwise. And we determined that the Nooksack WIRA 1 area is one area that really does face the most uncertainty, conflict, and risk to its water supply. Next slide, please. And this is why we're looking at a planned adjudication in WIRA 1, which we call the Nooksack. An important part of WIRA 1 are the area treaty tribes, Lummi Nation and Nooksack tribe. And I'll say here that both Lummi Nation and Nooksack tribe have submitted petitions to the Department of Ecology asking for adjudications in state court in this area. And that was important to the department. We have these petitions, we have requests from the tribe with whom the state has a government-to-government relationship. And these tribes are asking us to bring them and their treaty rights to water into the state court for consideration in the state regulatory system of water. Now, we understand that tribes have very early claims to water, as one would expect. Most of us have known that for a very long time. We know that tribes have rights to fish under their treaties. We know that tribes have reservation lands and presumably water that goes with the reservation lands. But we've never really understood how much water that is. And we could sit down and wonder about it, or I could go to one of many meetings that I have with tribal staff going out on the beautiful Lummi Peninsula, or meeting with Nooksack tribe, and we can talk about it and look at maps and talk about fish. But we have never had this final determination of how much water that is. And that is something that did happen in the Aquavella adjudication as to the Yakima Nation. And the Yakima Nation asked the court to recognize a tribal right to water, water on the reservation land and water for fish. This is a really important question. And I recognize here that it's a daunting question. It's uncomfortable to think about the water in our system and where it might go and who has a right to it. But it's been our decision within our water program under our director, Laura Watson, and with the governor's office and the legislature, that this is a good time to get that question answered. It's not a question that's going to go away. It's not a question that's getting any easier. And the time is now for us to look at water pressure when we see issues of climate change, we see issues of flooding and scarcity in the summers. We see declining fish populations, and we see, like Mary mentioned, orca populations all relying on this water. And we've determined that sooner is better to get these water questions looked at. And so the area we're looking at for adjudication at this point is the entirety of the water resource inventory area, included in the red and pink boundaries here. And the reason for that is because when we are going to be in the jurisdiction of the court and open this up for court venue, we're looking at resolving all outstanding water claims and uncertainties within this area. Could I have the next slide, please? So what I'm going to talk about here is the entire adjudication process. Now, the first time I said it was like as simple as I could say it process, and I'm going to go into a little more detail here, make it a little more complicated because I want to answer a lot of questions that we've heard both in preparation for this and just throughout our assessment process. So the first step here in blue is that ecology in the first step in the adjudication process. Oh, I'm going to turn off my camera here too, because that might help. You don't need to see me. Ecology first defines the source and identifies water users on this source. And this is what ecology is doing during this biennium, which means from summer 21 to summer 2023. We have staff, we have GIS mapping and IT staff that are working on preparing for the adjudication. And what we're looking at is identifying and defining the water source within the WIRA. This is going to include both surface and groundwater users. We're looking at all of our records, which are called permits, certificates, and claims. Claims in this sense means uses of water that go back to the original water code in 1917. When they adopted the water code in 1917, they said that it shouldn't, anything that happened from then on, the permit requirement shouldn't affect people who already had water in 1917. But then in the 1960s, the legislature passed another law that said, okay, that may be true, but we need everybody to register their claims because it is too difficult to just allow folks who've been around a while, no matter how much we might want to, without having any records of that. And so those are our claims. They're called claims registry claims. They could be dated from the 60s and onward. And we have many, many records of claims. Many of the claims do not represent actual water use. Folks tend to like to fill out forms and turn them in those situations just in case. And we want to be sure we contact everybody who has a claim on record and see if they're still using that water. We're also identifying permit exempt water users according to rural parcels. And what we're doing now is we're looking at what rural areas are not currently served by active water use. So what this means is that we don't want to serve everyone who's a City of Bellingham water customer. If you're a customer of the City of Bellingham, that water use is not part of the adjudication because, of course, City of Bellingham and other cities as well have thousands of customers, and those customers are using water under the parent right, the actual big umbrella right of the city. So the city's right itself will be in the adjudication, but there's no need to adjudicate each individual customer. Permit exempt users, on the other hand, have individual wells, and if these are wells for homes, the adjudication does need to have a record of these water uses. I'll talk a little bit more about that in detail in a few slides, and we'll also have more information about that in future meetings. So that's what we're doing in the preparation period for adjudication. And then the next bullet here in green is that ecology files in Superior Court. Our current target for this is June of 2023. And that is an estimated date. It's really the earliest we could file adjudication. This is a large agency process, and we're doing everything we can to be ready by then. But of course, there are things beyond our control and other things that happen in the world and in the process that that's our own internal, project target. That's not a deadline for us. And so that is something we want everybody to understand, that's the month that we want to imagine, or the year we want to imagine, but it's not a deadline for our purposes or for anyone's purpose that we have to file at that time. But as of 2023, in June, that is the filing target. And filing means we will provide the court with a statement of plan and map of the area to be adjudicated, including a list or probably a computer file of all users on record for that. And after that, we will notify all parties by mail and provide service for the adjudication. Everybody who should be involved will be getting service and notice, and everybody will also be doing more outreach along these lines through your local governments, conservation district, extension, and however else we might be able to get out and reach people to be sure everybody understands that the adjudication is going forward. The next thing that happens in the adjudication is that ecology, and others as well, anyone who's involved, whether it's a tribe, irrigation district, county, or other, is going to talk to the court about what the process should look like. And that includes what the deadlines should be, whether we want to group the process into large and small water users, tributaries, or otherwise, kind of the rules of the game. So that's a bit of our meeting that we, coaches put their heads together with the referees at the beginning of the game and talk about the house rules. And so that will happen at the beginning of the adjudication, and the court will make the final decision on those kind of deadlines and process to start the case. Next slide, please. So this is the long-term process of adjudication. This is how things work, the nuts and bolts of it down the road. The adjudication process involves water users responding to their notice with a claim and supporting evidence of their water use. And this is the moment that I know a lot of people are concerned about. And I want to explain what I can in its simple terms today, but also assure you that we'll have a lot more detail and support as the process goes forward. Water users will be asked to provide their claim and tell ecology and the court how much water they have used and when. We are preparing right now our online document resources and working with the courts to establish e-filing processes so that this can be done as much as possible online. We also know that in-person testimony is not required. The old-fashioned way of doing this was that everybody was sworn in and stood up in front of the judge to tell the judge on the record with the court reporter taking notes about their water use. A lot of this has been streamlined so that anyone could do that by affidavit. They just need to sign it and swear that they're telling the truth about what their historic water use is. If they need to provide supporting evidence, if it's not clear where and how much water was used, they might want to have additional documentation for that. We're going to have a highly supported process on that will be like a permit application or change process that will have staff available to assist people so that they have, for one thing, everyone will have all the documents available that ecology does. And we'll also have staff available to help identify what other information would be useful. After water users provide their claims, ecology will review these and prepare reports of findings. So a report of findings is like a review and a suggestion to the court. And we're not going to do this in one huge report of the whole county at once. We'll do these in a rolling process of reports as we go. And when a report of findings comes out, of course, we'll provide that directly to anyone whose water use is in the report. And if anyone disagrees with ecology's report of findings, they may object. And that could be the water user within that report of findings, or it could be a neighboring water user who disagrees with the finding on their neighbor's water use. Like everything in the adjudication, the court will make the final rulings and make the final decision about the legal water use. And at the end of the process, the court issues a final schedule. And this is the schedule that we're talking about, that is the inventory in order of priority that lists the water user, quantity, purpose, and place of water use in the final schedule. And this is really the long-term slide. This is not what's going to be happening in 2023. This is what's going to be happening for the years following that, for the lifetime of the adjudication. Okay, can I have the next slide, please? And here's a slide that breaks down the Nooksack into subbasins. And this has some interesting information on it, which are water right totals throughout the subbasin. This is information from our water right system. This does not include permit exempt private well owners. This includes documented water right holders. So as you can see, the largest area of water rights is in the lower Nooksack, and that is a subbasin that includes many smaller tributaries. But in that area, for instance, we have many permit applications. We have almost 2,000 claims. Those are those old water right claims representing use possibly going back before 1917. We have permits, and then we have certificates that are water rights that ecology has approved in the past. And that's a subbasin with a large amount of water rights in it. And then some of the other ones you can see relative to that have very few water rights in them. Chilliwack is the basin far up in the mountains that is national forest area. Upwards of the North Fork is as well. One thing about the adjudication is that this proceeding will join in the tribes and the federal government into the lawsuit. And so that will mean Lummi Nation and Nooksack tribe who have asked for the adjudication, as well as the Forest Service, the Park Service, and any other federal claimants who use water or have land in the entire watershed. That could include the U.S. Bureau of Reclamation. It could include other departments or agencies that might have lands. It could include the state DNR, any agency or local government and the federal government that own land or claim water in this area. And so that is a useful way of looking at how the rights break down throughout the area. Next slide, please. So this next slide talks about the challenges in WIRO 1 and some of the things that led us to conclude that adjudication is the best next step in this area and is the pathway that we want to travel in order to reach the destination of better water management and fairness in the area. And to talk about this, we have Rhea Burns, and Rhea is the regional manager of the Northwest Regional Office. And Rhea, if you'd like to go ahead and take your turn here with the slide.
Great, thank you, Robin. Barbara, just quick sound check.
Sounds good. Thanks.
Great, thank you. As Robin mentioned, I am Rhea Burns, and I am the Northwest Regional Manager for the Water Resources Program. Our regional team has offices in Bellingham in your backyard and in Shoreline further south. We oversee water resource management in the Nooksack watershed, or WIRA 1. I was asked today to speak to some of the unique water resource management challenges in the watershed, and Robin already touched on many of them. Within Washington, WIRA 1 has some of the most complicated records of historical water right documents. In terms of the overall quantity of the documents, and that previous slide visually showed that, as well as the interrelationship among the permits, certificates, and pre-code claims. Water right documents here often have overlapping attributes, and it is difficult for resource managers, such as our permitting staff, to differentiate valid water rights from those that are duplicative or have potentially been relinquished due to non-use. This complicated documentation makes water management challenging in the Nooksack. While recent flooding has demonstrated that there is too much water during some periods of the year, it is widely recognized that there is insufficient water available in the summer months to meet the current in-stream water needed for fish and out-of-stream demands for water. Ecology is keenly aware of the need for additional water solutions to meet the present and future needs of people and the in-stream resource. Yet, developing long-term water solutions requires verification of existing water rights. In order to identify potential solutions to these demands, resource managers need a watershed scale understanding of valid water rights. In addition to the complex pattern of state-issued water rights and water right claims, federal and tribal water rights are currently unquantified, and Robin elaborated on that earlier. Federal and tribal water rights may extend geographically from the headwaters to the Nooksack Delta, and managing state water users without clarity around the seniority and extent of these federal and tribal claims is especially challenging. By clarifying water rights in terms of quantity and priority, through this judicial process, water rights can be more easily changed and transferred and can be more easily used as the basis for solutions. With that, Robin, I'll turn it back to you. I think next slide, Barbara. And I think Robin's going to speak to permit exempt wells and how they will be treated in the adjudication.
Thanks, Rhea. I know we have a lot of questions and concerns about permit exempt wells. And here I'm talking specifically here about smaller permit exempt wells, what we call private wells, and domestic uses. All permit exempt wells under RCW 9044 have a right equal to that established by permit. And this only refers to groundwater, and it comes from when the groundwater code was adopted in 1945. The legislature allowed that in general, water users did not need a permit if they were using water for up to 5,000 gallons a day. And even though they didn't need a permit, they have a water right for the water that they have used that is equal to that as if they had a permit. And so that's what that first quote is from there. That's from RCW 9044. The law provides that in an adjudication, the court can provide a simplified process for small permit exempt well users. And that is, for instance, individual domestic well users. That does not necessarily include all permit exempt well users, since some could be much larger, but that is a specific detail we don't have answers for at the moment. A simplified process means simpler than what everyone else will be doing in the adjudication. And what we are aiming for in that process is one that is able to identify where permit exempt wells are, who is using them, approximately the quantity that they've used, and when that use started. So for instance, that could be a home with an address the date the home was first occupied, and the approximate amount of use by a family, or by a single family on a single well. And that would be the information we would look for from that particular well. Ecology's goal in adjudication is to protect homes from interruption from senior water rights. And so we are going to be in court, working with the court, working with other parties as necessary, and explaining to them that the homes that are using these wells need to have a year-round supply of water, and that we will work with the court on ensuring that that water is not interrupted. There are a lot of more complicated questions about permit exempt wells, and I don't know how many of them I will be able to answer today, but we are looking at having another information session like this specifically for permit exempt wells as the year goes along later in the year with our future webinar events. Next slide, please. So we also want to talk a little bit today about other work that we have done on water solutions in the Nooksack. And for that, we have Casey Cycler, and Casey works in Whatcom County. She is a Whatcom County resident and has worked for many years from ecology on this work. And she will speak to you a bit about other things that are going on in the long term. And just to put this into context, this is work that is ongoing, that is alongside adjudication. And this is also the kind of work that adjudication is going to facilitate in the long term.
Great. Thanks so much for that introduction, Robin. Again, my name is Casey Cycler, and I've been working for the past 16 years or so out of our Bellingham field office. I'm familiar with a lot of the names here, glad to see you here tonight, as well as a lot of new folks that I haven't had the opportunity to work with. So welcome. If you didn't know it, yeah, we have a field office for ecology up here in Bellingham. We opened the office about 30 years ago, very specifically to help provide community technical assistance and solutions to environmental challenges in our region of the state. This has included work on water quality, shorelines, spill response, as well as toxic cleanup and other things. Specific to water resources, we've also worked very hard to accomplish solutions and provide technical assistance. We have done that, and that was one of the factors that our office opened up here back in the 90s to find solutions to water resources issues. This has included several millions of dollars we've provided in grants to work towards community solutions. We've got a photo here on the slide of one of those grants that was accomplished by the Bertrand Watershed Improvement District, where they took groundwater and augmented Bertrand Creek during a low flow period. It was a great project. We had really appreciated working with the Watershed Improvement District on it. We also recently granted the City of Linden several $million to build a managed aquifer recharge project, and that will capture high flows during, for example, flooding periods, and retime that water for release during lower critical flow periods, again, providing more benefits to stream flow. And as well, we've provided technical assistance on a multitude of other solutions up here. Specifically in regards to adjudication, wanted to let you know that Whatcom County has proposed and is leading a settlement process that is set to run in parallel with and in addition to ecology's adjudication process. Again, this is a county-led process. But I really want to highlight for those here tonight that we absolutely are engaged and we are dedicating resources to actively participate in the process. If a settlement process is successful, it can be enfolded into the adjudication process by the courts. There are specific opportunities for this, and so we look forward to moving ahead with the settlement discussions. As I understand it from the county, the status of the settlement process is still in the development phase, but just want to assure everybody we will absolutely be at the table, and we are looking forward to engaging further on that once Whatcom County is ready to have us at the table. In the meantime, we welcome input from the public on Ecology's engagement in that settlement and encourage you to reach out if you have questions. Also wanted to let you know that historically we have had some really great success with settlement up here. We cooperatively developed with the Lummi Nation and state water users a court-approved settlement agreement for water rights on the Lummi Peninsula. That's been very successful in Ecology's eyes and has brought about, I think, a lot of calmness and appreciation that water issues that were once really complex and concerning to a lot of water users have been settled. We have also engaged in other attempted water settlement negotiations over the past 15 years up here in the Nooksack. It's something we are very supportive of, and we look forward to continuing to engage and work in solutions in this process as we move forward. Next slide, please.
Thank you, Casey. I'm going to focus now specifically on the next 2 years, approximately, of the adjudication, starting in where we're at now in 2022. What Ecology is doing now is working on preparing for the adjudication. We have about a biennium, that's 2 years of funding and preparation work that we are in the middle of now. We're working on data systems design. So that's all of the databases that will store our claimant names, individual parcel numbers, maps, and all the information that we'll need for that. We're identifying water users. We're working with the courts on preparation and conducting outreach. Early in 2023, we'll be preparing our final water user lists. We'll be preparing legal documents for filing, and we'll continue outreach to answer questions as we go. In June of 2023, that's our target date currently to file the petition in the Superior Court. Again, that's a target date. That's not a hard and fast deadline, but that's the date that we want people to have in their minds who are curious or interested in adjudication as the time when the filing is estimated. The court in June of 2023 will begin to set the initial deadlines for the case. Later in 2023, we'll be conducting service of our summons to water users, and we'll be beginning to make subbasin and pathway decisions, and that is geographical areas of the adjudication, how that will be divided up, and to talk about whether there are water users who are higher priority to go earlier on, or categories of claims such as federal and tribal, or major claimants such as cities and utility districts that might be on pathways separate from smaller water users. Those decisions about how that will happen, mapping out, would be occurring later in 2023 if the adjudication is filed in June. Next slide, please. This is our thank you slide. So this has the information here for going to our website. Our adjudication webpage talks about Aquavella and adjudication, and it also has links to our blog and other information that we've been updating regularly. And here, Chris Anderson's going to do his magic here. If you've ever been at the Water Rights Advisory Committee at the first Monday of every month, this is how Chris navigates us around the website. there's an information here, and Chris is actually the one that does the website in the first place. So he's the expert here. Thank you. We have updated this so that there is the best information that we've got available. One thing that happens on this, Chris, maybe you can show us, sometimes when you click for a focus sheet or a report, it will take you to a landing page. And like if you click on the adjudication report or the focus sheet, yeah. If you're on the ecology website and you get this landing page, do not be deterred. Keep going through the first link. I know I used to come to these and think, oh, I must have the wrong screen. But all this means is that there's a hard copy of a document like a PDF that comes up. So when you see that landing page, keep going. It just takes a minute to load, and that will give you the document that you're looking for. This is our adjudication assessment report itself, but there are also focus sheets available that are specific to the area. And this is a great way to get information that is more specific than what we've can cover today. Well, we were able to cover that information in less than an hour. And Barbara is telling us here in the chat that a recording of this meeting and presentation will also be available, which is one reason that we want to do this. We know not everybody's going to be available to come to something like this. Also, honestly, we had really hoped to do something like this in person, and maybe by the end of the year, we will be able to visit up in the county individually. If you send a chat to Jimmy Norris, who is our communications manager, he will be sure to get us the questions, and we'll be answering those as we go. And we also have individuals that submitted questions in advance. I actually took time this afternoon to look through the questions and really tried to answer a lot of them as I went. So hopefully, if you had a question, maybe you heard us answer it as we went. And we also, I think Jimmy's also got some of those ready to go.
Yeah, we've got a handful of questions. Let me pull up the first ones. This is from the pre-submitted batch. My father possesses a DOE water rights certificate for his farm from 1968. Are we vulnerable to lose these documented rights?
Okay, thank you. That's a great question. And I like having a specific example of someone. So the question is, there is an ecology water rights certificate for a farm from 1968. So ecology has an index, our water rights tracking system, that has all of the permits, certificates, and claims in our database, and they are also all mapped within our GIS system. And so everyone, like your father, this individual's father, or whoever now owns the land that that water right was listed for, will be notified about the adjudication. And so that's kind of the first step of what will happen here. If you or your father or the previous owners of land that you own have paper, have a certificate or other document, we will be sending you notification of the adjudication. A certificate in particular should identify a place and quantity authorized for legal use as of that date. So your father's certificate should have the date 1968 and say where and how much water is legal to use at that time. That is a great thing to have. It's a great starting point. If you had a certificate and lost it, the Department of Ecology has it, and we have that on record. You can find it by going into our Water Rights Search Explorer and pulling it up there. So that is the starting point for looking at the water use. And it's a great to have a certificate that shows us what the legal water use was as of 1968. Now, this next step with that would be understanding how much water has been used under that water right since 1968. And so if a water right has gone more than 5 years using only part of that water or none of that water, the water right can relinquish, and that means it goes back into the public domain for subsequent water users. Now, relinquishment is a complicated legal question. There are reasons that a farm might not be using water every 5 years, such as crop rotation, planting a different kind of crop, or a new development. or all different kinds of reasons, climate and otherwise. And so that is something that the adjudication would look at. So a water certificate from 1968 is not automatically entitled to that exact quantity of use in 2022 or 23 and on. It depends on how much water has legally been used. And so that quantity that has been legally used of beneficial use is the legal quantity that would go on the adjudicated inventory, and it would have a priority date of 1968 or a little sooner, depending on the date of the original permit application. So that's a really general answer. That's not legal advice about this individual certificate. Of course, that was just an example kind of given off the cuff there to hopefully help people understand how that all fits together.
Okay, and then the next question is, when is the presentation for private well owners and what data should they be gathering in preparation for adjudication?
Okay, that's a good question. We aim to present to small permit exempt well users this fall. That will be giving us time to develop our system and understanding what the issues are and what the alternatives are going to be for small private well owners. As far as what data they should be gathering, in this simplified process that we've mentioned, we will need to know the approximate quantity and when the use started and where it is located. And so if you've purchased a home that's on a well, it would be good for you to know how long that home has been there and how long it has been on the well. And that's the kind of information that would be good to have from a small permit exempt user.
Okay, and then next one is, I am a non-treaty commercial salmon fisher and our harvest is in Bellingham Bay. Do we have standing in this case?
Thanks, Jimmy. That's a good question too. We talk a lot about fisheries in relation to tribes because we get a lot of information from tribes, and tribes are such an important part of the community and such an important part of the fish ecosystem. But of course, there are also non-treaty commercial fishers that take fish out directly out of the river system and out of the bay. So standing is a specific legal term that depends on a bunch of different things about individuals' relationship to the law in the case. And so again, even though I used to wear a lawyer hat, I want to be careful here in such a large event. I'm trying to talk to you all like, you know, we're all sitting around a table and here's how I would try to explain it, but need to be careful. To be clear, this isn't legal advice. Not that anybody would rely on me and play a video of me if they were trying to have a lawyer, right? But what I want to be clear about is standing is a decision that the judge would make about who can participate in the case. Anyone who uses water or has an interest in the water will be notified and can participate in the adjudication. People who have other interests about the water source and what happens can ask the court to participate, or even to submit information they have that they think the court would be interested in. And so sometimes, like in courts of appeals, there are briefs that are submitted from friends of the court. And so if someone has information and says the court really needs to understand what's going on here, there are ways to submit that information to the court, regardless of the standing of that individual. But I also want to say that we're interested in learning more from commercial salmon fishers about this. I know that there's fisheries participation in the WIRA 1 planning unit and management processes. I don't know how much we've heard directly about that, but I would be interested in learning about from commercial fisheries and non-treaty fisheries about their concerns, especially about Whatcom County and Nooksack area stream flows. Because if those are different, it would be good for, if different than tribal concerns, it would be good for us to understand that. In general, tribals' concerns with stream flows are that there is adequate water for fish. And there are also, I'm going to go into a different answer here and talk about state stream flows for fish. We didn't have a slide for that because that really goes beyond the introductory level. But the state of Washington adopted a stream flow in 1985 throughout the system intended to be protective of fish. And that 1985 stream flow minimum is a state water right with a priority date as of 1985. And so from 1985 forward, water uses are junior to the stream flow that was set at that time to protect fish. And that is a really useful benchmark, a really useful regulatory point. It does not protect fish from any water use before 1985. And there are also many ins and outs as far as seasons, levels, tributaries, and so forth with those stream flow rules. But I wanted to squeeze that in there because I know many of you probably have heard about the in-stream flow rules and have questions about how they fit into adjudication. And the answer there is 1985 stream flows, and this is Washington Administrative Code WAC 173-501 that you can look up. Those in the adjudication, we will ask the court to adopt those as water rights on an inventory for 1985 priority.
Okay, and then this one comes from the chat. It might be a similar answer to the 1968 one, but it says, as a senior water rights certificate holder, 1939 surface water right, what will I need to do for this process of adjudication?
Thank you. So if you have a 1939 water rights certificate, again, it's really cool if anyone has their own original paper for that from their family or from their property. That also should be in the ecology water right search that you can access. And we have a copy of that. So we will be finding you, or you can come find us. And we will be sure that the current owner of the land associated with that water right has notice and is served about the adjudication. So the question in that will be the same as I was mentioning with the other one, which is how much of that water has been used from 1939 till now. And there are different ways that we can look at that information, and we can work with the water user to get that information. If it's had the same owner during this entire time or from the family, then it might be more straightforward for the family to write out. They, again, don't need a live testimony in court, but to do kind of an affidavit and talk about water use over time. If the land is passed through other hands, it might be more difficult and might need to look at additional information, such as crops on that land, aerial photos, and the other kinds of information we have historically that helps us understand that. And so those are just examples of the kinds of information that we need. And this isn't the final notification of that or a final description of that process.
All right, and next, and this one's kind of a theme. I've seen a few similar questions. Did I understand, Robin, correctly that the adjudication will encompass more than the Nooksack River system? How many different sources other than the Nooksack River are recognized within RIO 1?
Yeah, so we could back up actually, Chris, to the map that has the subbasins. This one right here, thank you. Yes, we are looking at adjudicating the entirety of WIRO 1. That includes, so yes, you understood that. We are making this decision in the coming months, in the coming year. The final recommendation we have will be what we submit to the court with our filing. And anyone who disagrees with the filing will be able to contest that with the court or ask for modifications to the map. In this area, the forks along the middle of the, just in the middle of the map here, North Fork, Middle Fork, and South Fork are the major tributaries to the Nooksack, and then the lower Nooksack flows into Bellingham Bay. Other areas have different levels of connection to the Nooksack system itself, but There are connected aquifers in some areas, connected streams. Sometimes it depends on season and stream flow. We understand that those flow in different directions and have different hydrology, but we're looking at adjudicating the entirety of the area. So this is something that we're able to do under the law, is designate the area for adjudication to the court. We are looking at adjudicating the entirety of the WIRA because there are issues throughout the WIRA about water management that are important to state regulation. And these areas or water are also within the petitions of Lummi Nation and Nooksack tribe that have requested the adjudication of the area. So while we have venue open in Whatcom County Superior Court, we are looking at adjudicating the entirety of WIRA 1. And this is what we've been saying, that we mentioned this at the WIRA 1 Management Board, and we have been working to communicate with everyone throughout the WIRA during this process, and we're going to continue to do so.
Okay, and next question, also from the chat. To mitigate the challenges of research, site visits, conversations, etc., will you be using local water conservancy boards?
Local water conservancy boards. So I don't know if this is something Casey can speak to, because I haven't worked with conservancy boards in WIRA 1. Conservancy boards are something that we have a lot of in Eastern Washington, and we have improvement districts in WIRA 1. Casey, do you have any ideas about this question?
Yeah, we don't have a conservancy board here in Whatcom County or in WIRA 1.
Okay. Yeah, so we are also looking at adjudicating in Eastern Washington in the Lake Roosevelt area, although that is kind of specific to Lake Roosevelt and reclamation districts. So conservancy board process and how that meshes with adjudication process might be an interesting one, but I don't think that's an issue what we're looking at here on this map today.
Okay, and next one is about wells. What about old wells from former small homes that are now used for irrigation?
You know, that's an interesting question. That issue of wells, if it is within the permit exemption, it needs to have a permit if it's not under the permit exemption. So that's one question. And then the other thing that we would look at is, you know, the well needs to has a water right along with the to the extent that it's beneficially used. So those are the kind of more curious questions that will be addressed in adjudication by the well user, showing the history of their water right and the dates of priority of that history. So that kind of example might be one that's a little more complicated than the simplified process, but it would depend on the quantity and how complicated it is. But we would want to know when the water was used, and if it's being used for more than a single home, we would want to know how much and when that use has been happening.
Okay. Next up is, how will you establish tribal water rights?
So it's a good question about tribal water rights in adjudication. Lummi Nation and Nooksack tribe, who I believe I saw representatives from the tribes on the call, and they are often happy to speak about this directly in forums such as the WIRA 1 Management Board. The tribes will be defendants in this lawsuit. They have asked for the lawsuit, but the state of Washington will be suing the tribes in this. And tribes will, like all claimants, need to be bringing their water right claim to the court for its review. And so the tribes claiming water with anywhere on this map will need to bring their legal basis, whether it's their treaty, presumably, and other information, legal or otherwise, that goes along with that. As well as historic information, if appropriate, to ask the judge to make determinations about that water. I know that that's an important question. Anybody in the adjudication can then take a position on the tribe's claim. The state of Washington will be reviewing those claims. That is certainly not at the my personal level of review. That's something that we'll be doing with the governor's office and the attorney general to look at the tribe's claims and looking at the law and the history of the area and taking a position on how the state responds to those claims once we see them in court. The judge in the Whatcom County Superior Court will make the decision on that. And if anyone disagrees, it will be appealed through the state to the State Court of Appeals and the state Supreme Court. And then certain questions of law could be appealed from there to the United States Supreme Court, but that would be a very kind of down the road advanced questions.
All right, and can you give me an example of water settlement negotiations?
Sure, and let me give an example that we saw in a different kind of question, actually one that came in separately about the Yakima Basin Integrated Plan. And I think that this is a good example. So settlement just means parties coming together to work it out. People use the word settlement in all different kinds of ways. It could be a settlement of a very simple lawsuit. If it's a car accident and there's a fender bender and parties, insurance companies are arguing, they could take that all the way to a small claims court, or they could do a handshake and insurance company could sign something and work it out to pay the money without going all the way through the court. And so we use many different things when we talk about settlement. So one example is if parties all agree before they get to the court, they can settle and not go to court at all. With something as complicated as an adjudication, it is very unlikely that all parties will agree on all water rights within WIRA 1 before going to court. And that is a matter of time. And it's also something we've seen just throughout history. We've been working with water in this area for over 30 years now and have not been able to have a comprehensive settlement of all water rights. So once the adjudication is in court, parties can settle either all or part of their water claims. They could settle with each other if that's where the dispute is. They can bring settlements to the court. And there's actually a provision in the water code about adjudications that if ecology and any party agree, we can bring that to the court as a settlement. Actually, we have to bring that to the court as a settlement. And everyone has a chance to weigh in on that. But if no one objects, then the court will just adopt that settlement. So that's an example of what happens. A large comprehensive settlement of many or all concerns is something that is more advanced, that is possible to happen. And that is something like the Yakima Basin Integrated Plan, which is a complex long-term solution for water that came out of the Aquavella adjudication. And that is, as the Aquavella adjudication proceeded, before it was finished completely as to all subbasins, but as the large issues began to be resolved, the parties determined that they preferred more holistic solutions than simply turning off and on water and moving gates and ditches to shut water off for individuals. And a comprehensive, complex solution came about that involved building storage. It involved working on fish passage, direct habitat protection, conservation of water, and a water market feature that trades water among water users seasonally. And that's the kind of comprehensive solution that gets water where it's needed most, when it's needed, and also looks at direct protection of fish and habitat where the priorities are, that became possible due to the adjudication in Aquavella. In Whatcom County, we're looking at currently many individual habitat solutions and some storage solutions like the ones Casey Cycler was telling us about. We believe that adjudication is part of the pathway toward the ultimate goal of doing that kind of solution more broadly throughout the basin. And I'll go a little into a little more detail about that here, and mention that one reason that the state adjudication is a great tool is that it brings federal parties into the process. And I see we have Joy from the Forest Service here. I don't know if we have other federal representatives as well. Adjudication brings federal representatives both on behalf of tribes and directly from the Department of Interior into our area, so that we have the federal government looking at settling out these issues on a very large scale. And where we see federal government involved, we often have the door opened to more comprehensive solutions. And that's because the federal government has a large interest in water. And of course, Congress has the authority to adopt many more large scale and fund many more large scale solutions. And that's something that we saw in Aquavella and in other areas throughout the West that could become possible by having this kind of general stream adjudication.
All right. Okay. Are water associations treated the same as exempt wells?
So that's an interesting question. The permit exemption goes up to 5,000 gallons per day for domestic use. So there are a lot of limitations on a permit exemption, and most water association, I mean, depending on the water association, a larger water system like a Group B system probably has a water right. And so again, the permit exemption is for 5,000 gallons a day or less. The simplified process is for small exempt well users that can have a simple accounting, such as, you know, date, quantity, dates of occupancy of a home. It's a good question, and I would like to learn more about that, about kind of larger exempt uses, and that's something I'll want to learn about, talk to people in our region and to our experts, and talk about at a further presentation, because I want to understand more about that to get into more detail.
Okay. And how did adjudication in Yakima benefit farmers?
Thanks. Well, I think the key about adjudication in Yakima is that it resolved the uncertainty that was had to do with all farmers on the mostly on the United States Bureau of Reclamation water, who were vulnerable to interruption by Yakima Nation. And the adjudication resolved the question between Yakima Nation and farmers off reservation and non-tribal farmers. Yakima Nation has irrigation rights as well as fish rights. That kind of certainty provides for a lot of long-term investment in the area and the ability to trade and have water markets in the area. There are also areas in Aquavella on the Yakima Basin Integrated Plan where, for instance, they were able to build storage and reservoirs by saying, you know what, this area is actually, we care more about having this area shaded than having, you know, one less farm on the stream, or we care more about having fish passage, you know, that in sometimes has more benefit to a population than the degree of water, or shading the stream will cool it more than another few gallons of water is. An integrated plan allows for practical solutions on that. The other big benefit there is in an ability to market water that is not available unless we know where the legal water is. So a farmer might decide that this season or that, for many other reasons, market pressures, if a certain crop isn't selling or certain things are going on in their family, maybe it's time to take a break, to be able to lease their water and roll it over to a different crop. They can make money off of that year that they're not using water. Someone else can roll in and use the water during that time. And they can have markets that move water to where it is needed the most. Other places, the water could be permanently dedicated to mitigation if someone is no longer farming and is going to be using it, and it could be sold to be used for another area. Another way that farms can benefit is stock water, which is particularly traditionally an exempt use, not limited to 5,000 gallons a day. Certificated stock water is a valuable kind of water right that we don't get unless we have an adjudication. And it could be that if an area is being used for stock, that water right, once certificated, could be leased, changed, or transferred for value to other uses. So those are some examples of how that helps.
Okay. Are water rights or claims not associated with the Nooksack River watershed treated differently or as a different class during the process?
That's a good question. So looking here on the map, we have the Nooksack system, lower Nooksack, and then north, middle, and south. We have the understanding that the water rights claimed by tribes are throughout the WIRA. So if this question is coming from a tribe on a treaty, in that case, no. They are all very similar depending on whether it's a right for fish or a right for reservation land. If this is for a consumptive right in a certain area, we imagine that those rights will be adjudicated in clusters based on their area. And so it'll have to do with the timing of that and the compartmentalizing those so that each area not related to the Nooksack can be done on its own time frame. And those could be done concurrently or before or after the related Nooksack, for instance, Three Forks and main stem rights.
All right, and what if certificated water land has been divided into many different parcels? Where does the water right go? How is the water use measured? Our well does not have a meter.
Yes, most wells don't have meters, do they? That is something we're discovering right now. We have staff that are going through our Water Right Explorer system, and maybe they're here. If they are, I would like to shout out to our staff, Lee and Jenna, who've been doing this, looking at each water right, looking at the legal description, mapping that onto the county GIS parcels, and then finding the owner of each current parcel. And that's been a huge effort that our staff's been undertaking. At this point, we're just beginning that work to understand how much is going on. We actually don't require every time property is sold for folks to update us. In fact, we've often said, don't bother us and don't update us on that, because that would simply be a huge volume of information. So for an old certificate, it's not surprising at all. And what we're finding is that many times these old certificates are, for a larger quarter and of agricultural land that is parceled off, and there is not documentation of that. And so what we will want to do is notify all current owners of that, and then look at how much water is used under the certificate. The history of the different water that comes out of the well and how it's been used. Of course, if there was a meter and historic metering records, that would be great. That would give us kind of firsthand account. If we don't have that information, and where we usually won't have that information, we'll be looking at estimates and other ways of determining how much water has been used on different parcels.
Okay, so that pretty much answers this other question. Are private wells going to be metered? So we can skip that one.
Are private wells going to be metered? We really want to talk more about private wells later on in the year. Our position is private wells on homes need to be able to continue without interruption. I'll just say right now, there are concerns when we have a permit exempt system and where we don't have any documentation of water use, that it's one thing to say, of course, it's fine to have a house there, but then it's another thing to wonder if that use will be enlarged or expanded. And so we're looking at ways of understanding that so that the permit exemption isn't abused. And I just wanted to kind of put that limit on it That doesn't necessarily mean metering or otherwise, but it is something to think about as we think through the best way for this to be managed. Is we don't want to promise that anybody can just take whatever they want out of the well just because it's never had a permit. That wouldn't be fair.
All right, and then if someone bought property now and wants to drill a permit exempt well, that's still acceptable, correct? Even with the impending adjudication?
Yeah, so the adjudication is not what directly affects that, but your use of water that's never had a well on it is something that you need to talk to your local Bellingham field office and possibly to the county about. Because there is a rule, the 1985 rule, and there's also the other planning that's going on out there that affects when new wells can go in and where they need, for instance, a building permit. So there is a notice of intent form for drilling a well, of course, and there's also limitations on how water can be taken out of a well with a permit exemption. So I would encourage anyone considering that to look into it carefully.
Okay, and here's another one. Okay, if someone has no documentation and we've contacted Ecology to do a search in addition to using the online tool and nothing comes up, is it fair to say there's nowhere any documentation could be found? Put more simply, if the user and Ecology has no documentation, it's fair to say no permit, claim, or application exists for that water use?
Well, that's something that we'll be thinking about as we go forward. Our documentation, we saved everything and we scanned everything in. And so if there are missing permits, there's going to be questions of whether there was ever documentation of that water use or whether it was somehow lost along the way or misfiled. So I don't know. I don't want to jump to the conclusion on that of what the conclusion would be. But we, it used to be, before it was the Department of Ecology, it was the Department of Engineering and otherwise. And we do have paper records going back to 1917 in this area. So we really should have everything. If there's not documentation, then that's something, a question we'll have to really think about what the evidence is that that's legal water use.
Okay, and let me just jump in here. I think we got time for one more question that'll have a short answer because we're running very short on time. And if we didn't get to your question, I apologize. But my email is jimmy.norris@ecy.wa.gov. If you send your questions to me, I will make sure someone gets you an answer. But we've got time for one last question, and that's what kind of records and information does Ecology have on file, and how can users access these records?
So that would be great if we could put the water rights search link in the chat. I don't want to do that but I bet Chris can do it. We have a water rights search that doesn't even require a login now. Look at this. I want to find a water rights search. So we can zoom in. So not everybody is snazzy as this as we can, but you can, I know that there's ways to look at the map. Look at all those water rights in Whatcom County. This is fun to have a live demonstration of this. You can look at the area. I think you can also type in address, name, or otherwise. It zooms in very nicely there. And this is all just on the public facing website of the Department of Ecology. And that will bring up the water rights there. So that is the way to get started to look at water rights on your land. And I think if you remember nothing else out of this, that's probably the most valuable piece of information that we're going to get to you, which is this is a good way of getting started at looking at the legal water that we have mapped for your area.
All right, and once again, Casey was kind enough to put my email in the chat. please, if we didn't get to your question, send me your question. I will try to find you an answer. I will try to find you the person who can answer it. But we are just about at time. Mary, did you have anything in closing?
Thank you, Jimmy. Thank you, Ecology team, for providing this information. And as you've heard, we're very interested in working with you and answering your questions and staying in close touch with the community throughout this preparation phase. So thank you for spending the time with us this evening. Please do send us your questions. We greatly appreciate your interest in this important subject. With that, Jimmy, I think we can close out.
Yeah, and I just wanted to say thanks everyone for listening to me. Thanks for your patience with this process, for your support from the community. I know we've talked to a lot of you. Not everybody is of the same mind as far as this process, but I have become confident over the years that everyone has a very similar commitment to the people, community, and environment of the area, and ecology does too. And we see this pathway as the best possible avenue to reaching integrated solutions in the area. And it's really been an honor to work with your community. I look forward to the day we can come back and meet in person, and really want to keep the lines of the communication open. And I appreciate everyone who's educated us as we go and who's had patience with us throughout this process. And we will see you again. So in closing, I think Jimmy and Barbara will be able to tell you how to follow up and where there might be a recording of this down the line.